Good afternoon. Welcome on in to another episode of From Day One. Courts are ready. Let's have an interesting little case from civil hearing.
Edwards versus Guerra, file number
p.m. on Thursday. I believe that was Thursday, October 20th. It may have been the week before, the 13th, but I was going to allow her to attend an alcohol and drug evaluation at Hunter Clinic in Wichita, and the appointment was for 3:30, and I was going to allow her to leave at 1:30 with the understanding that she would be back no later than 7 p.m. that same day. Again, the plan was to review and see how the evaluation and everything went and see if that affected my revocation order. Upon termination of the hearing, it was soon brought to the court's attention that she was suspected of being in possession of a stolen car that she would have driven to court that day, October 11, and that when officers went to check the car upon her entry into the jail, they found that it allegedly had felony drugs and paraphernalia in it.
Ooh.
And she appeared on those new charges earlier this date at 1:30. That case was set for preliminary hearing control December 2nd at 1:30, and Mr. Favre was kind enough to take a new appointment for that case. So here we are to just review the revocation, and I'll give each one of you a chance to make a brief comment, and then we'll proceed. Ms. Gillette, we'll start with you. Again, we're limited to review of the previous orders.
Your Honor, on the previous orders, we filed a motion to modify the release order, and the judge, you had granted that. She was supposed to have an evaluation that didn't happen, and you were going to take that into consideration as to what your sentence would be. At this time, the state is asking, because she had stipulated previously, and we were going to base our recommendations on having an eval and a bunch of other stuff done. The state is recommending a 60-day sanction at this time. That in the meantime, during the 60-day sanction, that a drug and alcohol evaluation take place. Ms. Mears had indicated earlier on her prior hearing she thought her mom might have been making arrangements for that to happen. if it does happen, then we would recommend she go directly to treatment. Her new case involves drugs. She may be eligible for Senate Bill 123 on that matter. Don't know. I haven't looked into the rest of her criminal history yet. But at this time, we would ask for a 60-day sanction on misdemeanors.
Okay. Mr. Aubrey?
Judge, that is an agreed upon recommendation. Ms. Mears, this behavior is clearly indicative of a person with a substance abuse issue. Ms. Mears, however, has obviously also been making some steps to try to address it. It's
No,
not
she isn't.
great behavior, but she's been pretty forthright about that. So we're in agreement with the 60-day sanction, and I'll just inform the court that Ms. Mears intends on resolving her other case as quickly as possible. In fact, she's willing to waive prelim today and get it sent over to a district court judge if you're willing to do it today instead of waiting till the second. But we're looking to resolve that other case because we are almost certain she's going to be Senate bill eligible. Obviously, she'll have to be screened, but based on her criminal history, she should be eligible. And she is in need of that treatment, so she's ready to move forward. And she has taken steps to talk to her mom about an evaluation, as well as hopefully get into KISA, life recovery in Sudan if possible, which I know she told you about earlier today. She also thinks that she'll still be able to get employment when she's released at Amazon, but that's kind of a hope, so we'll see.
Ms. Mears, I did revoke your probation previously.
Yes, Your Honor.
I am going to order that you serve your sentence, which on count 1, the domestic battery was 6 months in jail. And on count 2, the criminal probation property was 12 months. Your controlling sentence will be 6 months. You will get credit for all time served to date. I'm not just going to order a 60-day sanction. I'm revoking and having you serve your full sentence. I'm not going to take up your arraignment or your waiver of preliminary hearing in the other case until that date in December.
Okay.
I may or may not consider any kind of review later, but in this case, that is the order, and you are to serve it.
Okay. So I need to serve 6 months, correct?
12 months was the controlling term.
Judge, so we would move to modify that to a lower term. This is her first time out. I understand that the court's not happy with her behavior, but this is her first time before the judge on a probation violation. And it's the first time with a person who has, again, taken some accountability for her addiction. Slapping her with 12 months is not going to help her addiction at all. So the 60 days is more akin towards helping her with that addiction. And I would also point out that even if she was to get into Senate bill, which she likely will, this 12-month sanction will slow up her progress on Senate bill treatment, which will, as the court knows, guarantee her probation and put her out. So it seems detrimental and also not productive to any kind of recovery to slap her with 12 months. I would say modify the sentence to allow her to get out when she gets done with her probation when she gets her plea done, which she's trying to do, but anyway.
Well, counsel, if you felt that 12 months was so inappropriate, why would you plead the felony down to that sentence?
Judge, because obviously this is a person who has very little criminal history, and we're attempting to work with the state to get her the help she needs and also address the state's needs. I'm not saying that 12 months is inappropriate for what she pled to. I'm saying where she is now with her treatment desires as well as where her other case is, it's detrimental to the entire process to slow up the felony case for her to do the 12 months. Doesn't make a lot of sense.
This was a 21 case, and on March 4th, both counsel told me that was the agreed upon right sentence to make, that I should give her a 12-month controlling sentence, and I took your plea agreement and I adopted it and made it the order of the court. And now you're telling me what you recommended to me is wrong. I didn't give her what you all told me to give her.
What we're trying to say, Judge, is that whenever you do a plea agreement, you always have an underlying sentence. But when a person comes back on a probation violation, it's normal for the court to treat them where they are at that time, and that's what we're asking for. It's very common, especially in a felony case, to get dips and other intermediate sanctions. We're arguing at this point for an intermediate sanction. If the court's not willing to give an intermediate sanction, then we'd ask the court to consider modifying the sentence, because ultimately what's in the best interest for the community is to have a sober misdemeanors as opposed to just an incarcerated misdemeanors.
You don't think a year from now she'll be sober if I keep her away from booze and drugs?
I think it would be sober, but I think it would stop her from developing the tools she needs to work in the community. She's not a person that should be cut off from community-based programs. She has very little criminal history.
Well, what I'm hearing is I'm not supposed to mean it when I say, here's your sentence, and if you don't follow your probation, you're going to do your sentence. I'm not supposed to mean that when I say that?
I think you I think you do mean it every time, Judge, but I think that this is something where an intermediate sanction should be considered, because that is where a person is at the time, and that's where she is at the time of probation. She obviously made some mistakes. She's been upfront about it. She hasn't been in denial about it. I'm saying treat her where she is, not don't mean it in sentencing. Of course you mean it in sentencing, but it's a joint recommendation for both the state and I that she be allowed to have some kind of treatment option in the community, and a 12-month sanction just sets that back.
Well, I gave her that option, and then she lied to me. She told me October 11th that she quit using drugs, and she hadn't. And this charge in this case, one of them was for criminal deprivation of property, and then I'm told that she's committing at least criminal deprivation of property with a car that's reported stolen, and I'm not judging that right now, but I'm just saying I find that an interesting point in this case.
Certainly it's not uncommon for people with drug addiction issues to also have theft issues, but I would point out that she doesn't have even charges for that yet. That's what the state's alleged. She doesn't even have charges for that yet. So.
Right. Well, counsel, that's my order for today, and I'm willing to think about that and think about it between now and December 2nd when we see her again. That's my order for now. Thank you. We'll be in recess.
Yes. That honor definitely means it. Alright, let's see what else we got. Alright, let's see. Oh, that's right. Karen versus the bank.
I'll give a few more minutes. Midland Credit Management Incorporated versus Lori Hitt. This is case number C20G5727GC.
Good morning. Jerry Baig, BAIG, P36820, appearing on behalf of plaintiff and the attorney of record.
Yes. Lori Hitt.
Yes, you're under the idiots here.
Alright, Ms. Hitt, are you in a safe location?
A safe location?
Yeah.
The library. University.
That's not what we asked.
Can you hear me?
Yes, I can hear you. It's just last time we were here, you said that your neighbor was, I don't know, having marijuana smoke.
Yes, yeah. All kinds of problems at home.
But
It was blowing into your apartment,
Yeah.
and you were feeling as though you were becoming intoxicated.
affecting my
So
health.
that's why I, what?
Yes, it's been affecting my health for quite a while. Yes, I'm at the university and the library. I don't have internet service at home.
Alright. So,
Your Honor, it's up to you.
I think today is up for the plaintiff's summary disposition motion. But have you guys had a chance to discuss this?
Your Honor, we've had several hearings on today. No, if she's willing to try to discuss settlement, we can discuss that. If she's not, then let's just go ahead and proceed. We've already had several hearings on this case.
Well, ma'am, are you wanting to go in a breakout room and talk to him?
No, there's nothing to discuss. I put it all in motion to dismiss. I'd like to
File
see.
a motion to dismiss?
Yes, I did. I sent them a copy and you a copy.
Alright.
And I don't have any.
Alright.
I don't even have an income. They're not allowed to garnish Social Security wages, which I haven't even started receiving. I don't understand why they are trying to use me as some kind of a precedent so they can take advantage of everybody that aren't able to pay their excessive fees.
Alright, well listen, this is what I'm gonna do. The motion for summary disposition, I think, was filed theirs first. You filed your motion to dismiss on January 17th.
Okay.
We noticed ours on December 10th of 2021.
Well, I'm gonna hear the summary disposition motion first, and then the motion to dismiss. So, Mr. Banks, go ahead.
Your Honor, this is a motion for summary disposition brought under C9, C10. Basically, the defendant's position on this is that the filing of the lawsuit is somehow harassing her. Arguments don't make sense in this regard. But in any event,
Wait. I want you to address your motion to summary disposition. I can ask you to talk about your response to her motion in a minute. But let's just, make it, I've got two different motions.
okay, I'm gonna make it brief. I think our written motion, brief, and exhibits are substantial. I'm gonna pretty much stand on that, but I'll say this: we've shown the chain of title. We've
Dude, I've known from public speaking. Do not use You're just undermining credibility with each and every one of those.
documented our case with account statements and other documentary evidence. She has not, in her response, provided any documentation
Dude.
refuting our documentation. Actually, since we submitted it, our documentation, as per required by the court rules, then the burden is on her to show documentation to the contrary. She can't rest on her mere allegations, and that's what she's resting on. She's arguing that somehow Midland Funding does this and that.
Wait, Mr. Bay. You're mixing the two things here. That might be a response to her motion to dismiss. I want you to tell me about why you feel you're entitled to summary disposition. And since when is there a shifting burden situation?
Assuming that we met our burden, which I would argue we did. There is the brief outlines the legal basis for our motion and why it should be granted. With regard to documentary evidence, we submitted account statements that show payment and purchases made by Miss Hitt. Let's see what else. There is and I believe she's denied ever using the card. There's affidavit of account. Bill of sale assignments. Letters sent to her before the filing of the.
Wait, Mr. Bay. She says in her pretrial questionnaire, the first sentence under factual statement. I have never used a Capital One store card for Walmart nor was issued a card as I believe was promised before the unforeseen circumstances. Blah blah blah.
The answer is immaterial because discovery was sent to her, including requests for admissions, which she didn't answer. So the requests for admissions are deemed admitted, and they override anything that she's alleged in her answer. Those are also attached as an exhibit. Based on all that, we're requesting that our motion for summary disposition be granted.
Ms. Hitt, what do you have to say just on the motion, your response on the motion for summary disposition? Then we'll get to you making your argument about your motion to dismiss.
I don't see why they're pursuing this when they're not. I don't have an income for them to garnish, and I never was issued a credit card for Walmart from Capital One, and I don't know what questions he's talking about that I did not answer.
You don't know what you don't know what he's talking about?
Some questions that I did not answer. I don't know what he's talking about. Several other things.
They say they sent you during discovery a request for admission. A list of questions, where you were to deny or agree with the statements made.
I never used the card. He just misrepresented right there. I never used the card. I never got a card. and he's, all due respect, he's completely twisted around the circumstances about my requesting documentation about their bill of sale for purchasing a debt from a creditor when I'm claiming unjust, what is that called? Unjust rewards. Well, how can I defend myself if I don't know how much they paid for an account that's already written off for insurance and tax purposes? And all the lawsuits are saying, even the Supreme Court is saying how sleazy, quote, the word sleazy, the debt buyers are on Midland Credit Management and their affiliates.
Wait. What Supreme Court said that Midland Funding's debt buy practices were sleazy?
I don't have it with me.
Yeah, this is the day to argue the motion. Come on.
How can I defend myself when they won't provide me proof of how much they have paid in order to collect all this money? They shouldn't be able to collect a 5,000% profit on something they paid pennies on the dollar for.
Why would you say that?
If they
Why
paid,
would you say they're prohibited? Wait. Why would you say they're prohibited from doing that? Because the fact is, they're not prohibited from doing that. You can buy and sell debt. And when somebody buys a debt, they have provided that it's within the statute of limitations, they have a right to try to collect it.
Correct.
And that's how they make their money.
there's a limit on how much interest you can charge on an account.
That's true. But I don't know if we're talking about, when you say the account, are you talking about when it was still a credit card, or at what point are you talking when it becomes a court judgment? I mean, yeah, there are limits.
Well,
Interest is different than how much they paid for the debt. And whether or not they're allowed to make a profit when they bought a debt that they're allowed to collect on. So. Okay. Anything else?
just they absolutely have violated the Fair Debt Collection Practices Act in all the ways possible.
Okay, let me ask you about that. So, are you going to be presenting evidence that they violated the Fair Debt Collection Act as it applies to your case?
My testimony.
Okay.
Ma'am, I'm asking you something really more specific. Look.
Are you going to be not stupid, Your Honor? I mean, Karen.
We could say for example, that Ted Bundy is a mass murderer and a bad guy. He was a mass murderer or a bad guy. Now, if there was a somebody that died or was murdered, you know, you'd still have to prove that Ted Bundy murdered that particular person. I mean, in other words, you know, the fact that they are, somebody may be a bad character or they may have practices that you don't agree with, you got to be able to show some linkage between that particular type of behavior and how it might apply in your situation.
Well, all you'd have to do is go online and check their court cases, their
That you're supposed to
the
do.
Better Business Bureau has 4. There's class action suits against them. My testimony is as good as any other third party as a witness.
I don't know what that means. What does that mean?
Means nothing, Your Honor.
My testimony is as good as any witness, other witness. If they,
Well, let me ask you this. Yeah, there have been lawsuits and class action lawsuits. Are you a part of any of the classes
no, they're also very,
as plaintiffs in some of those lawsuits?
they're also very rude to me when they call. They're aggressive. They speak so fast. I have had a robocall. I looked at my phone. I thought I hung up on him. He did a robocall to me and hung up on me. That's not a violation.
No, that's not a violation.
Under no circumstances should any type of business, such a large corporation, be disrespectful, talk down to me, and demand me to pay money on a phone conversation, and I can't even see where I'm at with all of this. You're not really allowed to talk back to them to describe your situation.
Ma'am, let me ask you a question. Or a couple of questions, if you don't mind.
A couple hundred, please, Your Honor.
Let's say I go down to, I don't know, pick a bank. Chase Manhattan Bank. Or
Okay.
whatever. I go down to I'm not gonna name a bank, it doesn't matter. Let's say I
Other
go
than
to
you
the
just
bank.
did.
I go to a bank and I borrow $1,000.
Okay.
And I agree to pay the $1,000 back, because it's a loan. And let's say I go to that bank one day and for something that doesn't have anything to do with the loan, or maybe I'm over there to make a payment on the loan. If the teller is rude to me that day, let's say the teller's like really in a bad mood and is really rude to me. Okay? Does that mean that I'm not obligated to pay the loan back?
Well, I discussed it before how I paid them thousands and thousands of dollars.
No, ma'am.
That's not what we asked.
Ma'am, I'm not asking you about your case. I'm asking you in the context of this hypothetical. Because it sounds like what you're telling me is they're a big corporation that's rude and nasty, and they violate the federal debt collection law. So therefore, I'm not obligated to pay the money back. That kind of sounds like what you're saying.
Well, that's one of the things.
Okay, all right. Well, let me ask you a question, man. If you're alleging that they violated the federal debt collection laws as it applies to you, is that right?
Sure.
Okay. All
I
right.
like that one.
So,
Sure.
Did you file a counterclaim in this case, or you just basically said you're using that as a defense?
That's my part of my motion to dismiss.
Okay. All right.
That's part of my motion to be stupid, Your Honor. You know I like to be stupid.
Your Honor, this is the fourth hearing that I've been on for this case. You advised her to seek legal counsel. For some reason, she hasn't done it. Bottom line is that, even without the documentary evidence and everything else that we presented, she did not answer the requests for admissions. They are deemed admitted. They're just deemed admitted. She has admitted to every essential element of this case. Our motion must be granted.
She says she never got them. That's what she just said.
Well, there's a proof of service. She claims she never got the account statements. If you take a look at the account statements, take a look at the address. Same address as on the notice of hearing.
I don't even know what he's talking about now.
Oh. Really?
What's the date you sent the request for admissions, Mr. Bay?
Proof of service, which is in the motion for summary disposition, September 16th of 2021.
Would you please say that date again?
September 16th of 2021.
I got received 3 summons. Is that what you're talking about? Is that what he's talking about, Judge Miracle?
The request for admissions, interrogatories, and request for productions of documents, as well as the plaintiff's second pretrial conference questionnaire and the 67th 5th District Court pretrial questionnaire form were mailed to the defendant on September 16th of 2021. Now we're about 9 months past that date. She didn't answer the admissions. She didn't file any objections within the requisite 28-day period. They're deemed admitted.
Well, did you receive them then?
Receive which thing?
The interrogatories and the request for back in the fall.
Admissions for what? What would I? Admissions for what would I admit?
And then to top it off, Judge, hold on, Judge. And then to top it off, she received another copy of this as part of her motion for summary disposition back in December. Still no answers. They're deemed admitted.
Answers for what?
You instructed her to get an attorney, Your Honor, on more than one occasion. She didn't do so for whatever reason. She has no excuse for not answering the discovery.
Ma'am, did you try to get a lawyer on this?
Yes, of course I spoke to the legal services. I can't afford an attorney. I have a legal constitutional right. What right do you have to order me to get an attorney if I'm a citizen of the United States?
Really?
Your Honor, she says that she does no.
Wait, hold it.
She says that she does no.
If you would please stop being obnoxious to me and intimidating me. You're violating my Fair Debt Collection Act right now, the way you're speaking to me.
Your Honor, she says she's on Social Security. I
I
don't
did
think
not say that. You're lying right now. I did not say I'm on Social Security. You can't even keep the story right. You want me to send you a check for money I don't owe you. And you think that smirk on your face, you just think I am a joke.
there's no smirk on my face. Your Honor, please rule on the motion for summary disposition.
The motion for summary disposition is denied.
And just so that we have a record for purposes of appeal, can you please articulate your reasons?
Yeah, shut the fuck up.
There were issues raised in your argument that are fact questions. You argued that she didn't indicate that she didn't receive the credit card or not, or didn't, let's see how to put it. I can't remember exactly how you phrased it, but I pointed out in her pre-trial questionnaire that she denied, you said she didn't deny having this card, and that the burden was on her. I disagree on that, but
Well, the request for admission say otherwise.
She specifically did at a pre-trial questionnaire deny using this card or being issued the card. So that's a fact question.
Your Honor, just so I establish a record, the request for admissions, which she didn't answer when they were originally served and when they were put forth as an exhibit to the motion for summary disposition, they're deemed admitted. They override her allegations in her answer or any defenses that she raised in their answer or in her pretrial questionnaire.
No.
He is saying that
Well,
I didn't.
Mr. Vague, it's one thing to try to make the argument that, first of all, let me see the dates on the pre-trial questionnaire. When did you file your motion for summary?
In December of 2021.
Her pre-trial questionnaire was when? When was the pre-trial questionnaire filed, ma'am?
I don't have that with me. I believe I did. I think you told me I had this done. I've sent 3 different things to one to the court. The clerk told me I just didn't start out sending that, and I did send answer to them, copies to you and to them, and then I did the motion to dismiss.
It was filed September.
I have papers everywhere.
When did you send the request for the interrogatory?
They were served September 16th of 2021 and then also included as an exhibit to the motion for summary disposition, which was filed in December of 2021.
Well, you filed it after she filed her questionnaire, so the timing doesn't work out for you, Mr. Bay. It works in the opposite direction.
I would disagree, but that's fine here. I would just put my disagreement and objection on the record.
That's fine, but I mean, the court got her questionnaire early September, like September 3rd. motion for summary and your interrogatories. This is why I don't do this is why I don't hear this is one of the reasons why I don't hear SD motions until the close of discovery.
Well, Your Honor, you just said that you received a pre-trial question. Your Honor, you just said that you received a pre-trial questionnaire on September 3rd. The discovery that we sent is after that. So her failure to answer the request for admissions override what she has stated in her answer in her pretrial questionnaire. They post-date that.
No, we don't.
Well, I think it's a fact question. So, at the end of the day, I don't care. Listen. At the end of the day, you got to prove that you issued the card to her and that she used it.
You don't have to. The request for admissions, which she didn't answer, admit to those essential elements.
Okay, well, there are fact questions. That's just one.
And I would object. There's no fact questions. The request for admissions override all that. There is no question of fact remaining based on the request for admissions.
I don't even know what admissions he's talking about.
Well, ma'am, that's because you want to represent yourself.
I don't want to.
Well, yeah, you do. Because, yes, you do. I think that we provided the information for legal services, the Bar Association, lawyer referral service. Did we not provide that to you?
Well, I don't have any choice if I'm summoned into court. I don't have any choice. I don't have any choice.
You're ignoring my question. You're ignoring my question.
Of course he is, Your Honor.
I mean, we provided to you some possibilities for you to get a lawyer for free or very cheap. So, you made a point. You said nobody can order you to go get an attorney. And you're right. Nobody can. I can tell you all day long that I think you'd be better served to have a better opportunity to make your best case that a lawyer. There are lawyers who defense in this type of case, in this state.
It seems to me a lot of
But you decided, I don't know. I don't know what you decided, but for whatever reason, you're representing yourself. So, you can't, it's almost like you want to have it both ways.
Yes, please.
Well, the big complaints are they think that they are entitled to people's money when
That has nothing to do with you getting a lawyer or not, man. They're going to do whatever they want to try to do. They're going to
they know people.
That has nothing to do with whether or not you get a lawyer to help you do this.
They know people can't protect their rights.
Well, as a practical matter, I understand what you were saying. And I will even say that I don't know the arguments that you are making down to this particular situation. You know, that's what's going to happen on your side to be able to prevail. And probably having an attorney that does this type of work, there are several, probably be able to help you. But, you know, you can't complain about, I don't understand what's going on. And then on the other breath say, well, nobody can make me get a lawyer. I mean, nobody can make you understand either. So what do we do with that?
Well, I can't pay more to an attorney than what a debt buyer expects me to pay to them. That wouldn't make any sense.
I agree with you. I mean, well, let me say this. I understand what you're saying. And there may be, you know, as a practical matter, I think people make that kind of calculation. You know, on the other hand, maybe it makes, on the other hand, they're probably expending more to collect this debt than what it's worth to them.
I don't see how a Zoom conference would cost so much money.
Well, Mr. Vague is covering it for the attorney or money. So they gotta pay him.
Somebody should pay me then. Well, if you dismiss the case, they're not gonna pay me for my time, my anguish.
It doesn't work that way. I mean,
I have some of the.
okay, well, I'm denying the summary disposition motion. A motion to dismiss. I am,
What are you doing? Come on, you're on. Turn it. Reiner?
motion to dismiss denied at this time. Now, man, if you are able to perfect the motion by connecting the dots, so to speak. If you can connect the dots to say that these things that you're talking about, in the broad sense that these folks are doing, that they did it to you, and that by law you're entitled to a dismissal. If you can connect those dots together, you certainly can make another motion to dismiss.
Well, how would they be able to follow through on this if I don't have the income? They're not allowed to take my Social Security when I receive it, and I wasn't aware they were supposed.
That's more of a practical matter, isn't it?
They can't collect on it. They're not allowed. Why are they doing this to me? And I wasn't aware they.
The judge. Listen, ma'am. If they got a judgment against you, it would be good for 10 years, and they can ask them to be renewed for another 10. So you might be on a income income, or you're getting disability or something that they can't guarantee now, but there's nothing to say that, you know, you won't get the lottery or come into some money or, you know, anything could happen. I guess maybe that's what they're thinking.
I wasn't aware they weren't supposed to be accepting money from student distributions either.
The
For
what?
Student distributions, creditors,
Well,
before.
ma'am, nobody can make you get a lawyer, but if you go talk to a lawyer, maybe you can come up with a defense that is going to, I don't know.
Don't be dumb.
Okay.
You sound quite dumb right
So
now.
I guess I probably need to set a final free trial and file it. Huh?
Your Honor, do we have permission to supplement our motion for summary disposition and renotice it at the next pretrial?
No.
Well, how is your argument going to be able to change? I mean, the fact is, look, the whole case is about did she breach a contract to pay on this credit card, right? That's what the case is.
I want to supplement. I want our motion to be supplemented with the case law that shows that the requests were admitted or deemed admitted, and what I placed on the
I want to go
record
ahead and prove that you're an
in
idiot, Your Honor,
opposition to your
without saying it.
ruling is the correct interpretation of the law. You have to rule in our favor based on that.
I do not.
I do not.
It's a fact question. But I tell you what, Mr. Bay, you can ask me to reconsider. That's what you're asking. File a motion for reconsideration. You know, obviously you have that right.
We do.
You know, but I don't know. I think you guys just like spending time with me.
Well, you know I do, Judge.
You guys aren't trying to negotiate any kind of a settlement.
Try to.
No, you don't.
No, they did not try to. They just wanted to get whatever money they can get from me. The stipulation, if I say paid in full, does that mean they can come back and get more money from me later? That's not right.
Wait, whoa, what do you mean? What do you mean?
They sent me this
you might have
complicated
just.
document. I was willing to settle with them in the beginning.
Okay, well,
Whoa,
ma'am,
man.
if you guys come up with a settlement, the case would be
Done.
at best, it could be dismissed with prejudice. You guys would agree to that.
I did not.
Or you're an idiot.
Well, ma'am, I don't know what to do. I don't know what to tell you.
Well,
I don't know what to tell you.
they're so rude to me. I tried out.
Ma'am.
I can't. I don't.
I can't make them be happy and cheerful.
Maybe you need to be talking. Maybe you need to file something in federal court if they violated the federal debt collection law.
I can see myself representing myself
Oh,
here.
sorry. Which they haven't, by the way. Didn't think I told them to do that.
I have told you this on more than one occasion, and I feel like it's pointless to say it again.
Say it again. Say it again.
Okay? We're making some arguments that may have merit, but you have to be able to connect the dots.
Note the may part.
Show how it applies to you. You haven't done that, and you won't go get an attorney, because you want to represent yourself.
Well, an attorney would.
So that's where we are. So we'll have to have a trial, and it'll probably take a long time.
Yeah, like years.
But,
An attorney wouldn't be able to produce any objective evidence any more than what I'm telling you.
Well, I disagree with you on that.
So does the rest
How
of the
would
world,
they
you
do
know.
I couldn't. In fact, I'll go even further. I disagree a whole lot with you on that point, because there are attorneys who practice in just this area of the law. I mean, ma'am, here's what I don't get. You've done research about some of these different cases that have been filed against these folks, right?
Yes.
So why would you not just call or contact the attorneys that sued them?
They charge $500 an hour, don't they?
You contact any of them?
No.
Guess I spoke to the
No,
attorney.
ma'am. Ma'am,
yes,
listen to me. Listen, you wouldn't want to call an attorney that does adoptions of children on a debt collection case. I mean, if I was looking for a lawyer on a debt collection case, and if I'd done the research like you had to see all the different lawsuits that have been brought against them for violating the debt collection laws, et cetera, et cetera, et cetera, I would be trying to contact attorneys that successfully sued. That's what I would be doing.
So then they just want you to go
But
bankrupt.
you choose to want to represent yourself. And I think you're doing yourself a disservice. But that's, I think you're doing yourself a disservice.
Why should I
So
go?
that's all I'm going to say.
You're doing yourself
What's
the
that?
way.
Why should I go to bankrupt when I've been a loyal customer?
Filing bankruptcy is a completely different situation, man.
Well, that's what they'll just tell me to do.
I don't know. Maybe they will. Maybe that's the solution.
And I have
no idea.
the times in the past and in my.
Ma'am, I gotta move on. Ma'am, I'm moving on. I'm going to adjourn, have the clerk set it for final pretrial in 60 days. You guys want to negotiate? That's fine. No, I think I'm done speaking with it. I'm going to set it for final pretrial.
Thank you. And with that, we'll bring the afternoon session to a close. Please come back with us tonight. Frauditors, auditors, Faucets, and Karens will be with us. Until then, like, share, and subscribe. Be kind to one another, and release the Krakens as we march along this afternoon and every afternoon here from day one. Have a great afternoon. We'll see you tonight.